Let's pick up from Part 1, Jurisdiction Part 2. The Court of Appeals dismissed without prejudice the complaint for recovery of possession and damages that the petitioner filed before the Regional Trial Court of Cabacalan City, Negros Oriental, because the complaint failed to allege the assessed value of the disputed property in the case. Attached to the complaint, however, was a copy of a declaration of real property indicating that the assessed value of the disputed property is 20,790 pesos. Was the CA's dismissal proper? The answer is no. The factual allegations in a complaint should be considered in tandem with the statements and inscriptions of the documents attached to it as annexes or integral parts. The CA should have considered the facts contained in the declaration of real property attached to the complaint in determining whether the RTC had jurisdiction over the petitioner's case. A mere reference to the attached document could facially resolve the question on jurisdiction and would have rendered lengthy litigation on this point unnecessarily. Tumpag versus Tumpag, September 29, 2014. In 1998, respondents filed with the RTC an action for recovery of a 44-hectare parcel of land against petitioner. The assessed value of the land was not indicated in the complaint. The petitioner filed a motion to dismiss on the grounds that the action was for ejectment or that if it was an action publi shana. The court still did not have jurisdiction since the assessed value was not stated in the complaint. The RTC denied the petitioner's motion to dismiss, holding that it had jurisdiction over the case because the area of the subject properties was 44 hectares, more or less, and it is safe to presume that the value of the same is more than 20,000. Was the denial of the motion to dismiss proper? The answer is no. Jurisdiction is conferred by law. It cannot be presumed. When respondents filed the complaint in 1998, RA 7691 was already in force and it was approved on March 25, 1994 and took effect on April 15, 1994. As such, it is necessary that the assessed value of the subject properties or its adjacent lots, if the property is not declared for succession purposes, be alleged to ascertain which court has jurisdiction over the case. Despite the fact that the parcel of land was 44 hectares, it was error for the trial court to take cognizance of the case on a presumption. The reason is that jurisdiction cannot be presumed or conferred by the agreement of the parties. Regalado versus Dilorama, 2017, December 13. Plaintiff filed with the MTC a case for unlawful detainer against the defendant. The plaintiff averred that he had bought the property from the seller but had found the defendant staying thereon, that he allowed defendant to stay provided that defendant will immediately vacate the land upon plaintiff's prior notice that he will be needing the land, and that the defendant refused to vacate despite notice to do so. The MTC rendered judgment dismissing the complaint for lack of jurisdiction, stating that the proof showed that the issue of possession cannot be properly determined without settling the issue of possession. On appeal by the plaintiff, the RTC agreed with the MTC that jurisdiction lies with the RTC. The RTC then took cognizance of the case and rendered a decision in favor of the plaintiff, ordering the defendant to vacate the premises. On appeal by defendant, the CA reversed and set aside the RTC decision. The CA held that the RTC did not acquire jurisdiction over the case for plaintiff's failure to allege the assessed value of the subject matter, and as a consequence, the assailed RTC's decision is null and void. Was the CA decision correct? No. In real actions, there is a need to allege the assessed value of the real property subject of the action, or the interest therein for purpose of determining which court, MTC or RTC, has jurisdiction over the action. However, it must be clarified that this requirement applies only if these courts are in the exercise of their original jurisdiction. Here, the RTC was exercising its appellate, not original jurisdiction, when it took cognizance of plaintiff's appeal, and Section 22 of BP 129 does not provide any amount or value of the subject property which would limit the RTC's exercise of its appellate jurisdiction over cases decided by first-level courts. Clearly, then, in the instant case, contrary to the ruling of the CA, the assessed value of the disputed lot is immaterial for purposes of the RTC's appellate jurisdiction. Indeed, all cases decided by the MTC are generally appealable to the RTC irrespective of the amount involved. Hence, the CA erred in nullifying the RTC's decision for lack of jurisdiction. Arrienda versus Kalau, 6 April 2016. I'd like to read the note by Attorney Riguera regarding this case. It should be noted that the MTC actually had subject matter jurisdiction, since it is axiomatic in ejectment cases that the court may resolve the issue of ownership for the limited purpose of determining the issue of possession. Section 16, Rule 70. Hence, the result reached was correct for the reason that the action in the MTC was an ejectment suit. The holding, however, that the requirement of stating the assessed value does not apply to the exercise of appellate jurisdiction appears faulty. If the MTC had no subject matter jurisdiction, this defect cannot be cured by an appeal unless it comes within the terms of Section 8, Rule 40. Here, Section 8, Rule 40 cannot come into play since the RTC does not have original jurisdiction precisely because of the failure to allege the assessed value in the complaint. Next question. Plaintiff engaged X to construct a water tank for him for a price of $1 million. Plaintiff withheld delivery of the last payment of $30,000 to X since X supplier S had made a claim to the same. Able to determine who between X and S is entitled to the $30,000 payment, plaintiff filed with the RTC of Las Piñas City an action for interpleader against X and S to determine who between them is entitled to the $30,000. X filed a motion to dismiss on the ground that the RTC has no jurisdiction over the action. Should the motion to dismiss be granted? The answer is yes. The RTC has no jurisdiction over the case, since the amount subject to the interpleader does not exceed $400,000. Under BP 129, the MTC has exclusive jurisdiction over civil actions where the value of the personal property, state, or amount of the demand does not exceed $400,000. Makati Development Corporation versus Tanhuatco, 27 Scra 401. Note by the author. The ruling appears to be faulty. In interpleader, the plaintiff has no interest in and is not making any demand or asserting any right on the property, but is seeking only to compel the defendants to interplead among themselves. In essence, the suit is among the conflicting claimants, the plaintiff not making any demand against them. The subject of the litigation is thus incapable of pecuniary estimation. Q. P filed with the MTC an action for consignation, seeking to compel D to accept $250,000 in payment of P's obligation to D. D filed a motion to dismiss, arguing that an action for consignation is incapable of pecuniary estimation and hence within the jurisdiction of the RTC. Should the MTC grant the motion to dismiss? No, the MTC should not grant the motion to dismiss. The Supreme Court has held that an action for consignation is capable of pecuniary estimation as the amount sought to be consigned determines the jurisdiction of the court. Here, the amount sought to be consigned is $250,000, which is within the jurisdictional amount of the MTC. Hence, it is the MTC which has jurisdiction. Askew versus Court of Appeals, 196 804. Q. Plaintiff filed with RTC an action for specific performance to compel a builder to finish the construction of the house or to pay him the sum of $250,000. The defendant builder filed a motion to dismiss on the ground that jurisdiction is with the MTC since the amount of the claim does not exceed $300,000. The plaintiff opposed the motion to dismiss, arguing that the complaint to compel defendant to finish the construction is of one for specific performance and thus an action incapable of pecuniary estimation. Should the RTC grant the motion to dismiss? Would your answer be the same if what the plaintiff filed was an action for specific performance to compel the builder to finish the construction of the house and to pay him $250? The answer to letter A is yes. The alternative relief for damages was made the action for specific performance capable of pecuniary estimation. Hence, the jurisdiction lies with the MTC since the amount of the claim does not exceed $300,000. Cruz versus Tan. Letter B. No, my answer would not be the same. In that case, the action would be for specific performance and thus incapable of pecuniary estimation. The claim for $250 is not an equivalent of the action for specific performance since it was prayed for as additional rather than an alternative relief. P was a record owner of 100 shares of stock in the Manila Golf Club. Upon his return from the U.S., he discovered that the shares in his name were canceled and new shares issued in favor of the National Steel Corporation. P filed an action against NC or NSC and MTC to compel the assignment of shares of stock in his favor. Was the action to compel the assignment of shares of stock one which is incapable of pecuniary estimation? The answer is no. An action to compel the assignment of shares of stock in an action for recovery of personal property rather than one incapable of pecuniary estimation. Gotchan versus Gotchan, December 2001. Jurisdiction would be based on the value of the shares of stock. Philippine Bank of Communications, or PBCom, filed a petition for extrajudicial foreclosure of the real estate mortgage executed in its favor by First Sarmiento Property Holdings. First Sarmiento. The real estate was auctioned and sold to PBCom as the highest bidder. First Sarmiento filed a complaint for annulment of the REM with the RTC. First Sarmiento paid the docket fees for actions incapable of pecuniary estimation. After the complaint had been filed, the ex officio sheriff issued the certificate of sale in PBCom's favor. PBCom asserted that the regional trial court failed to acquire jurisdiction over First Sarmiento's complaint because the action for annulment of mortgage was a real action. Thus, the filing fees filed should have been based on the fair market value of the mortgage property. The RTC dismissed the complaint for lack of jurisdiction, holding that First Sarmiento failed to pay the appropriate filing fees. Was the dismissal of the action correct? No. The complaint for annulment or collection of a REM is incapable of pecuniary estimation, even if the property had already been foreclosed when the complaint was filed, since the ownership and possession of the property remained with petitioner. This is because at the time the complaint was filed, the certificate of sale was not yet registered with the Registry of Deeds. First Sarmiento Holdings versus Philippine Bank of Communications, June 19, 2018. In 1994, the Polamok Water District, a government-owned and controlled corporation, engaged in the supply of potable water to the municipality of Polamok, passed PWD Resolution Number 94023, imposing new and higher water rates upon its consumers. In 1994, the Polamok General Consumers Association filed with the RTC a class suit for the declaration of nullity of the resolution on the ground that it was passed without due notice to the members and hearing as required by PD 198. Does the RTC have jurisdiction over the class suit? Yes. The issue before the RTC was the validity of PWD Resolution 94023, which is incapable of pecuniary estimation. Polamok Water District versus Polamok General Consumers Association, 18 October 2007. Now, the following are cases not within the exclusive jurisdiction of any court or quasi court. Which court or body has jurisdiction over a boundary dispute between a municipality, like Kananga, Leyte, and an independent component city, like Ormoc City? The Regional Trial Court under Section 19, number 6 of the BP 129, the RTC shall exercise exclusive original jurisdiction in all cases not within the exclusive jurisdiction of any court, tribunal, person, or body exercising judicial or quasi-judicial functions. Under Section 118 of the Local Government Code, a boundary dispute between a component city or a municipality and a highly urbanized city shall be jointly referred for settlement to the respective sanggunians for the parties, while Kananga is a municipality or Mok is an independent component city. Section 118 is thus inapplicable, since there is no law providing for the exclusive jurisdiction of any court or agency over the settlement of boundary dispute between a municipality and an independent component city of the same province. The RTC would have jurisdiction pursuant to Section 19, number 6 of BP 129. Municipality of Kananga versus Madrona, GR 141375. Which court has jurisdiction over an action for recognition and enforcement of a foreign judgment? In this case, the judgment of the Hawaii District Court against the state of Ferdinand Marcos, awarding US $1.9 million damages to the human rights victims. The Regional Trial Court. Under Section 19, number 6 of the BP 129, the RTC shall exercise exclusive regional jurisdiction in all cases not within the exclusive jurisdiction of any court, tribunal, person or body exercising judicial or quasi-judicial functions. An examination of Section 19, number 6 reveals that the instant complaint for enforcement of a foreign judgment, even if capable of pecuniary estimation, would fall under the jurisdiction of the regional trial courts. This would be so even if the foreign judgment award did not exceed the jurisdictional amounts for the MTC. Mijares versus Granada, GR 139325, April 2005. Claim for money, exclusions from jurisdiction amount. P is going to file in Makati a complaint against D for collection of a promissory note in the amount of 350,000. The complaint also prays for moral damages of 50,000, exemplary damages of 50,000, and attorney's fees of 40,000. Which court would have jurisdiction over the complaint of P? The METC. In computing the jurisdictional amount, damages, attorney's fees, litigation expenses, and costs are excluded. Section 19 and 33, BP 129. Here, excluding the moral and exemplary damages and the attorney's fees, the amount claimed is 350, which is within the jurisdiction of the METC. Alfredo Reyes borrowed 300,000 from Danilo Chan, a resident of Makati, Metro Manila, for which he executed a promissory note dated June 14, 2006. In said promissory note, Reyes agreed to pay on or before 15 of June 2008 the amount of 300 with interest thereon at 21 per annum. Reyes defaulted, hence Chan filed a complaint for collection against Reyes with the RTC of Makati. The complaint recites in detail the terms of the promissory note and ends with this prayer. Wherefore, it is respectfully prayed that after due trial, judgment be rendered against Alfredo Reyes, ordering him to pay plaintiff Danilo Chan the principal sum of 426,000. The counsel for Reyes moved to dismiss on the ground that the court had no jurisdiction over the subject matter of the suit, since the principal indebtedness of Reyes was only 300,000. The motion to dismiss asserted that the difference between the sum of 426,000 claimed in the complaint and the debt of 300,000 represented the stipulated interest of 21 per annum for the period from June 14, 2016 to June 15, 2018. After due hearing, the court denied the motion to dismiss for the reason that the ground invoked does not appear to be indubitable. The counsel for the defendant filed a motion for reconsideration, which was also denied. How valid was the posture of the defendant in filing the motion to dismiss? The posture of the defendant in filing the motion to dismiss is not valid. The Supreme Court has held that the accrued interest on a loan is a primary and inseparable component of the cause of action, not merely incidental thereto, and must be included in the computation of the jurisdictional amount, where the debtor had agreed in writing to pay interest, and the accrued interest is determinable at the time of the filing of the complaint. Gomez versus Montalban. Here, the accrued interest of $126,000 should be added to the principal amount of $300,000. Hence, the total amount of the demand is $426,000, which is in excess of the jurisdictional amount of $400,000 and thus within the jurisdiction of the RTC. In the preceding problem, assume that the RTC denied the motion to dismiss. After trial, the RTC found that the accrued interest to which Danilo Chan is entitled to is only $96,000. The RTC then rendered judgment dismissing the case for lack of jurisdiction, stating that the total amount to which Chan is entitled to is only $396,000 and does not exceed the jurisdictional amount of $400,000. Was the RTC's judgment correct? The answer is no. Jurisdiction is determined by the cause of action as alleged in the complaint and not by the amount ultimately substantiated and awarded. Here, the amount of the demand, as stated in the complaint, was $426,000, which is within the RTC's jurisdiction. Hence, the fact that the amount ultimately substantiated and awarded was only $396,000 would not oust the court of the jurisdiction it had acquired. P was bumped by D's car, which was recklessly driven by D. P files an action for quasi-delict against D with the RTC of Makati. P's complaint prayed for actual damages of $350,000, moral damages of $50,000, exemplary of $50,000, and attorney's fees of $40,000. Does the RTC of Makati have jurisdiction over the case? Yes. Under Supreme Court Circular 0994, the exclusion of damages of whatever kind in determining the jurisdictional amount under RA 7691 applies only to cases where the damages are merely incidental to or as a consequence of the main cause of action. However, in cases where the claim for damages is the main cause of action or one of the causes of action, the amount of such claims shall be considered in determining the jurisdiction of the court. Here, the claim for damages is the main cause of action since this is a complaint for quasi-delict or torts. Hence, the moral and exemplary damages should be added to the claim for actual damages of $350,000 and the total jurisdictional amount is $450,000, which is thus within the RTC's jurisdiction. Note the wording of Circular 0994 is imprecise since a claim for damages is not a cause of action but a relief sought by the plaintiff. It is suggested that the circular be worded as follows. However, in cases where the causes of action principally involves a claim for damages, as in torts case, the amount of such claims shall be considered in determining jurisdiction of the court, quote-unquote, by the author. Santos' car was bumped by a truck driven by Pinion and owned by Inigo, the employer of Pinion. Santos filed an action for quasi-delict against Pinion and Inigo with the RTC of Manila. In the prayer of his complaint, Santos asked for $40,000 as actual damages, $300,000 as moral damages, $150,000 as exemplary, attorney's fees $50,000. The moral damages and exemplary damages were prayed for because of defendant's adamantine refusal to admit liability and to pay the actual damages. Who has jurisdiction over the action? The RTC or the MTC? It is the RTC which has jurisdiction. The moral damages and exemplary damages are included in computing the jurisdictional amount of $400,000, since said damages arose from the same cause of action, that is quasi-delicate. The total claim of 490,000 thus falls within the jurisdiction of the RTC. Inigo versus Puruganan, TR 166876, March 24, 2006. SC Circular Number 0994 note that the attorney's fees were excluded in computing the jurisdictional amount. Another way of looking at it is that since the action is principally for recovery of the damages, then the damages should be included in computing the jurisdictional amount. That is added by the author. Petitioner filed on August 22, 1996 with the MTC an action for damages with writ of replevin against the respondent, wherein it prayed for the return of the forklift return. Or in the alternative, if the return cannot be made, the payment of its actual market value of 150,000 and for the payment of unpaid rentals of 11,000 a month starting from April 1995 until repossession of the forklift. At the time of the complaint's filing, the outstanding and unpaid rentals had amounted to 180,000. Petitioner also prayed for exemplary damages of 1 million and attorney's fees of 50. Does the MTC have jurisdiction over the petitioner's complaint? The answer is no. The value of the forklift is 150. It cannot be said that the actual damages in the form of unpaid rentals is just incidental to the action for the return of the forklift. Considering that the petitioner had specifically sought not only the seizure of the forklift, but likewise the unpaid and outstanding rentals pursuant to SC Circular 0994, the 180,000 is included in the computation. 150 plus 180 plus 330, which is over the jurisdictional amount of 200,000. Hence, the MTC does not have jurisdiction. Movers, Base Co. Integrated Port Services versus Cyborg Leasing Company or Corporation. Note that the exemplary damages and attorney's fees are not included in the computation. D borrowed 250,000 from C, evidenced by a promissory note, which loan was secured by a chattel mortgage executed by D over his car worth 450,000. D failed to pay despite demand, so C filed an action with the MTC of Panaranaque City to collect 250 from D and or to foreclose upon the chattel mortgage. D filed a motion to dismiss for lack of jurisdiction. Should the motion to dismiss be granted? Yes. It is the RTC which has jurisdiction because of the alternative relief, which prays for the foreclosure of a chattel mortgage in the amount exceeding 400,000. Good Development Corporation versus 2-1. Plaintiff Bank filed a sum of money case, 350,000, against an auto loan borrower with the MTC of Pasay City. The plaintiff also applied for a writ of replevin and was able to seize the car valued at 500,000. The defendant filed a motion to dismiss on the ground that jurisdiction should be with the RTC. Should the defendant's motion to dismiss be granted? No. The Supreme Court held that in a sum of money case, jurisdiction is determined by the amount of the claim, not by the value of the vehicle seized under the writ of replevin. Fernandez versus International Corporate Bank, 1999. Filomeno brought an action in the METC of Pasay City against Marcelino, pleading two causes of action. The first was a demand for the recovery of physical possession of a parcel of land situated in Pasay City with an assessed value of 40,000. The second was a claim for damages of 500,000 for Marcelino's unlawful retention of the property. Marcelino filed a motion to dismiss on the ground that the total amount involved, which is 540, is beyond the jurisdiction of the METC. Is Marcelo correct? Marcelo is not correct. The METC has jurisdiction over the action. Under Section 33 of BP 129, The METC has jurisdiction over real actions where the assessed value of the realty does not exceed 50,000 in Metro Manila. Said provision also states that damages are excluded in computing the jurisdictional amount. Here, the claim for damages was merely incidental to the cause of action involving the claim for recovery of possession. Hence, the METC has jurisdiction over the action for recovery of possession of land since its assessed value did not exceed 50,000. Note by Reguera. There is an imperfection in the drafting of the question. The claim for recovery of possession and for damages are not cause of action, but simply the relief sought by Philomena. There is only one cause of action, Marcelina's unlawful retention of the property. Special Commercial Court. Petitioners filed with the RTC of Muntinlupa City a complaint against respondent GJH Land Incorporated and respondent officers of GJH Land seeking to enjoin the sale of GJH Land shares. The petitioners alleged that they had fully paid for the GJH Land shares, but the same were still offered for sale by respondents to GJH stockholders. The case was docketed as civil case number 11077 and raffled to branch 276, which is not a special commercial court. After filing their respective answers to the complaint, respondents filed a motion to dismiss on the ground of lack of jurisdiction over the subject matter, pointing out that the case involves an intra-corporate dispute and should thus be heard by the designated Special Commercial Court of Muntinlupa City. Branch 276 granted the motion to dismiss filed by respondents. It found that the case involved an intercorporate or intra-corporate dispute that is within the regional and exclusive jurisdiction of the RTCs designated as special commercial courts. It pointed out that the RTC of Muntinlupa City, Branch 256, was specifically designated by the court as the special commercial court. Hence, Branch 276 had no jurisdiction over the case and cannot lawfully exercise jurisdiction on the matter. Accordingly, it dismissed the case. Did RTC Branch 276 act correctly in dismissing the case? The answer is no. A court's acquisition of jurisdiction over a particular case subject matter is different from incidents pertaining to the exercise of its jurisdiction. Jurisdiction over the subject matter of a case is conferred by law, whereas a court's exercise of jurisdiction, unless provided by the law itself, is governed by the rules of court or by the orders issued from time to time by the court. The matter of whether the RTC resolves an issue in the exercise of its general jurisdiction or of its limited jurisdiction as the special court is only a matter of procedure and has nothing to do with the question of jurisdiction. In such a scenario, the proper course of action was not for the commercial case to be dismissed. Instead, Branch 276 should have first referred the case to the executive judge for redocketing as a commercial case. Thereafter, the executive judge should then assign said case to the only designated special commercial court in the station, that is, Branch 256. Gonzalez versus GJH Land, November 10, 2015. Note that the procedure would be different where the RTC acquiring jurisdiction over the case has multiple special commercial court branches. In such a scenario, the executive judge, after redocketing the same as a commercial case, should proceed to order its re-raffling among the said special branches. Petitioner Condominium Corporation filed an action for injunction with damages against respondents before the RTC of Makati City. The action was properly docketed as an ordinary civil case, not a commercial case, and scheduled for general raffle among all branches of the Makati RTC, including Branch 149, which is a special commercial court. The case was raffled to Branch 149. Respondents filed a motion to dismiss on the ground that Branch 149, a special commercial court, has no subject matter jurisdiction over an ordinary civil case. Should the motion to dismiss be granted? If not, may Branch 149 take cognizance of the case? No, the motion to dismiss should not be granted. Branch 149 may take cognizance of the case. The designation of Branch 149 as a special or commercial court by no means diminished its power as a court of general jurisdiction to hear and decide cases of all nature, whether civil, criminal, or special proceedings. The Makati RTC Branch 149 erred in dismissing the petition for injunction with damages, which is clearly an ordinary civil action. As courts of general jurisdiction, the designated special commercial courts and the regular RTCs are both conferred by law the power to hear and decide civil cases in which the subject matter of the litigation is incapable of pecuniary estimation, such as an action for injunction. Branch 149, therefore, has jurisdiction over the case and should take cognizance of the same. Concord Condominium versus Bakuliao, 2016, February 17. Petitioner Corporation filed an action for injunction with damages against respondents before the RTC of Makati City. The action was erroneously documented as a commercial case, not an ordinary civil case, and scheduled for a limited raffle among all the special commercial courts of the Makati RTC, including Branch 149. The case raffled to Branch 149, respondents filed a motion to dismiss on the ground that Branch 149 and Special Commercial Court has no subject matter jurisdiction over an ordinary civil case. Should the motion be dismissed? If not, what should Branch 149 do? It's almost the same. No, the motion to dismiss should not be granted for the same reason as stated in Gonzalez versus GJH. However, Branch 149 cannot take cognizance of the case as the same was wrongly raffled, that is, erroneously documented, as a commercial case and scheduled for limited rather than general raffle. The case should be referred to the executive judge for redocketing as an ordinary civil case. Thereafter, the executive judge should then order the general raffling of the case to all branches of the Makati RTC, including the special commercial courts. Concord Condominium versus Bacolio. K opened a securities trading account with RCBC Securities, a firm engaged in securities brokerage. Later, K discovered that X, an employee of RCBC Securities, had made unauthorized trades and diverted some of K's securities to other accounts. K thus filed with the RTC of Makati a complaint against RCBC, wherein he prayed for recovery of the money from unauthorized trades and the securities diverted to other accounts. The case was raffled to Branch 63, a non-commercial court, which referred it back to the executive judge because it was an intra-corporate dispute. Was the referral proper? The answer is no. The case is not an intra-corporate dispute, and instead, it is an ordinary civil action, triable by a non-commercial court. There is no intra-corporate relations between the parties. K is neither a stockholder, partner, member, or officer of RCBC Securities. The parties' relationship is limited to that an investor and a securities broker. Moreover, the questions involved neither pertain to the parties' right and obligation under the corporate code, if any, nor to matters directly relating to the regulation of the corporation. Ku versus RCBC Securities, 2018, October 17. Special Agrarian Court. What is the jurisdiction of the RTC sitting as a Special Agrarian Court, or SAC? The SAC shall have original and exclusive jurisdiction over all petitions for the determination of just compensation to landowners. So X was the owner of several lots. For purposes of placing those lands within the coverage of the CARL, the Development of Agrarian Reform Adjudication Board, DARAB, sent to X several notices of land valuation and acquisition by which her lands were valued for acquisition by the DAR. After X rejected such valuation of her lands, the DARAB conducted summary administrative proceedings for the determination of just compensation. The DARAB issued its order affirming the valuation of the lands upon finding the valuation consistent with existing administrative guidelines on land valuation. 2 months from her receipt of the DARAB's order, X filed in the Regional Trial Court (RTC), sitting as a SAC, a complaint for the fixing of just compensation for her lands, in pleading as defendant the Land Bank of the Philippines and the DAR. The petitioner prayed that the DARAB valuation be set aside and declared null and void, and that in its stead the price of her lands be fixed based on the fair market value thereof. The defendants filed a motion to dismiss citing Section 51 of the CARL and Section 11 of Rule 13 of the 1994 DARAB Rules of Procedures, which provides that the complaint should have been filed within 15 days from the notice of the assailed order. The RTC, as the SAC, granted the respondent's motion to dismiss. Was the grant of the motion to dismiss proper? The answer is no. The RTC, acting as SAC, had original and exclusive jurisdiction over all petitions for the determination of just compensation. The original and exclusive jurisdiction of the SAC would be undermined if the DAR would vest in administrative officials and original jurisdiction in compensation cases and make the SAC an appellate court for the review of administrative decisions. Since the determination of just compensation is a judicial function, the Supreme Court abandoned its ruling in Veterans Bank, Martinez and Soriano, that a petition for determination of just compensation before the SAC shall be proscribed and adjudged dismissible if not filed within the 15-day period prescribed under the DARB rules. To maintain the rulings would be incompatible and inconsistent with the legislative intent to vest the regional and exclusive jurisdiction in the determination of just compensation with the SAC. Indeed, such rulings do judicially reduce the SAC to a merely an appellate court to review the administrative decisions of the DAR. This was never the intention of the Congress. Land Bank versus De La Uta, August 8, 2017. Jurisdiction over labor matters. P was a sales representative of George Grotjan, or GmbH, and Company. She obtained loans and cash advances from the company. Later, she was dismissed and she filed an illegal dismissal case against the company with the labor arbiter. The company filed a suit with the RTC to collect the loans from P. P filed a motion to dismiss for lack of jurisdiction, contending that it is the labor arbiter which has jurisdiction over claims arising from employer-employee relations. The RTC granted the motion to dismiss. Was the dismissal proper? The answer is no. The jurisdiction of the labor arbiters and the Nlrc under Article 217, Number 5 of the Labor Code is limited to disputes arising from an employer-employee relationship, which can only be resolved by reference to labor laws or the collective bargaining agreement. Where the claim to the principal relief sought is to be resolved not by reference to the labor laws or the CBA, but by the general civil law, the jurisdiction belongs to the regular court of justice and not the labor arbiter or the Nlrc. Here, what is involved is a simple loan collection case which can be resolved by the civil code provisions on obligations and contracts. George Groton GmbH and Company versus Isnani, GR 1092-72. Otherwise put, while the claim is between an employer and an employee, the same did not arise from employer-employee relations. Employee filed an illegal dismissal case with a labor arbiter against employer. The employer, in its defense, contended that it had dismissed the employee on the ground that the latter was selling the products of the company of a competitor, Acme Corporation. The labor arbiter decided in favor of the employee and awarded damages and separation pay. Later, the employer filed a damage suit with the RTC against the employee. The employer alleged that the employee was promoting the products of Acme Corporation to the detriment of the employer, and thus it sustained damages. The employee filed a motion to dismiss on the ground of lack of jurisdiction. Should the motion to dismiss be granted? Yes. The Supreme Court held that the employer's claim against employee for alleged double dealing is one that should have been raised as a compulsory counterclaim in the labor case for illegal dismissal filed by the employee against the employer. The RTC has no jurisdiction over the case. Banyas versus Valdevilla. Note by the author, here the ground for the dismissal and the damage suit involved the same subject. The alleged double dealing, compared with Grotchan, where there was no showing of a nexus between the ground for the illegal dismissal and the non-payment of the loans. Unicorn Security Services, or USSI, a security agency which provides guards for Philippine Airlines. Because of USSI's breach of the security service agreement, PAL terminated the same after 30-day notice. USSI, as trustee for its security guards, filed an action for recovery of termination pay benefits against PAL before the labor arbiter. PAL filed a motion to dismiss on the ground that there is no employer-employee relationship between USSI and its employees on one hand and PAL on the other. The labor arbiter did not rule on the motion to dismiss. Later on, the labor arbiter rendered the decision in favor of USSI. The labor arbiter stated that since PAL is an indirect employer under Article 107 of the Labor Code, there is an employer-employee relationship between PAL and the security guards. Did the labor arbiter have jurisdiction over the case? The answer is no. The Supreme Court held that while PAL may be an indirect employer under Article 107, a perusal of Article 106 and 107 reveals that a company is only an indirect employer for purposes of liability for wages but not for any other purpose. There being no employer-employee relationship between PAL on the one hand and the security guards and USSI on the other, the labor arbiter was without jurisdiction. USSI's complaint should have been filed with the regular courts. Philippine Airlines versus Nlrc. Petitioner, a freight forwarder, hired the respondent as an employee. The respondent resigned from the petitioner and forthwith started working for ASPAC, another freight forwarder. The petitioner then filed an action for injunction with the RTC, praying that the respondent be enjoined from working for ASPAC and that damages be awarded to it for respondent's violation of the 2-year non-compete clause in the respondent's employment contract. Upon respondent's motion, the RTC dismissed the complaint, stating that the jurisdiction over the matter was with the labor arbiter. Which has jurisdiction over the case, the labor arbiter or the RTC? The answer, the RTC. Whereas here the cause of action is based on tort, which has no reasonable causal connection with any of the claims in Article 217 of the Labor Code or Labor Code, the jurisdiction over the action is with the regular courts. Petitioner does not ask for any relief under the Labor Code, but merely seeks to recover damages based on the breach of contract. Such case is within the realm of civil law, more so where the stipulation refers to the post-employment relations of the parties. Usen Air versus Villamore. What is a post-employment matter? It is a dispute between an employer and a former employee where the material or operative facts occurred after the employee-employer relationship has been terminated. Josephine was a bank teller at PCIB. She accepted a bank draft for a deposit to the account of Harrington after consulting with her bank manager. Later, an imposter was able to make withdrawals from Harrington's account. PCIB had to refund Harrington the amount of the unauthorized withdrawals. Subsequently, PCIB started deducting the amount of the unauthorized withdrawals from Josephine's salary, contending that Josephine was negligent in allowing the deposit of the bank drafts. Josephine filed a complaint for damages with the RTC of Makati City. She claimed that the PCIB had abused its right by gradually deducting from her salary the amount the bank had to pay Harrington. PCIB filed a motion to dismiss on the ground that it is the labor arbiter which has jurisdiction over the case. Should the motion be dismissed be granted? No. Article 217 of the Labor Code provides that the labor arbiters have original and exclusive jurisdiction to hear and decide claims for actual, moral, exemplary, and other forms of damages arising from an employer-employee relations. Nevertheless, when the cause of action has no reasonable connection with any of the claims provided for in Article 217 of the Labor Code, jurisdiction over the action is with the regular courts. Here, since Josephine's cause of action is based on a quasi-delict or a tort under Article 19 in relation to Article 21 of the Civil Code, the civil courts, not the labor tribunals, have jurisdiction over the subject matter of this case. Philippine Commercial International Bank versus Gomez. November 2015. Diana was hired by Malayan Insurance Company in 2004 as an employee. She was able to avail of a car plan in which she executed a promissory note promising to pay her 50% equity in the car to Malayan in installments, while the other 50 would be shouldered by Malayan. The car plan stipulated that if Diana was terminated within 3 years from her hiring, she should pay Malayan's equity and return the car immediately if she is unable to pay. Just a year into her hiring, Diana was terminated on the ground of redundancy. She was unable to pay her obligation to Malayan and also refused to surrender the car. Malayan brought an action for replevin with the RTC to recover the car, which was valued at $600,000 from Diana. Subsequently, Diana brought an illegal dismissal case before the labor arbiter against Malayan. Does the RTC have jurisdiction over the replevin case? The answer is yes. The action involves the parties' relationship as debtor and creditor, not their employer-employee relationship. Malayan's demand for Diana to pay the 50% company equity over the car or to surrender its possession is civil in nature. The issue in the replevin case is separate and distinct from the illegal dismissal case. Malayan Insurance versus Alibudbud, 2016 April. Respondent was directly hired while on tourist status by the PNB branch in Singapore. She was subsequently dismissed by the head of the PNB Singapore branch without notice and hearing. Back in the Philippines, she filed an illegal dismissal case against the PNB with the regional arbitration branch of Quezon City, where she resides. It is contended that the RAB has no jurisdiction over the complaint since respondent was hired in Singapore and thus governed by Singaporean law. Does the labor arbiter have jurisdiction over the complaint for illegal dismissal? The answer is yes. Section 10 of the Migrant Workers and Overseas Filipino Act of 1995 provides that labor arbiters of the Nlrc shall have regional and exclusive jurisdiction to hear and decide claims arising from an employer-employee relationship or by virtue of any law or contract involving Filipino workers for overseas deployment. PNB versus Kaban. Housing and Land Use Regulatory Board. What is the exclusive jurisdiction of the Housing and Land Use Regulatory Board? The Housing and Land Use Regulatory Board, or HLURB, has the exclusive jurisdiction to hear and decide cases of the following nature. 1. Unsound real estate business practices. 2. Claims involving refund and other claims filed by subdivision lot or condominium unit buyer against the project owner, developer, dealer, broker, or salesman. And number 3, cases involving specific performance of contractual and statutory obligations filed by buyers of subdivision lot or condominium unit against the owner, developer, dealer, broker, or salesman. CPD number 1344, Executive Order number 648, and EO 90. Case: Francel Realty Corporation filed a complaint with the Regional Trial Court against the defendant CCIP for collection of the balance of the price of house and lot under contract to sell. Previously, CCIP had filed a complaint with the HLURB against Francel for unsound business practices involving the sale of the same house and lot. Defendant filed with the RTC a motion to dismiss on the ground that the jurisdiction is with the HLURB rather than the RTC. Should the motion to dismiss be granted, would your answer be the same if there was no prior case filed by CCIP against Francel? Yes. FRC contends that the case is not cognizable by the HLURB because it was filed by the developer rather than by the buyer, as provided under PD 1344. This contention is untenable. FRC's complaint should have been filed with the HLURB as a compulsory counterclaim pursuant to Section 7, Rule 6 of the Rules of Court. Francel Realty Corporation versus CC. Second question, no. In that case, it would be the RTC which would have jurisdiction. The HLURB has no jurisdiction to take cognizance of a complaint filed by the subdivision owner or developer against the subdivision unit buyer. The wordings of PD 1344 reveal that it has jurisdiction over cases filed by the subdivision or condominium unit buyer against the subdivision or condominium owner or developer, but not the other way around. The developer, or the only instance when the HLURB would have jurisdiction over a case filed by the subdivision or condominium unit owner or developer, is if such case is filed as a compulsory counterclaim to an existing suit filed by the subdivision or condominium unit buyer against a developer, as in Francel Realty Corporation. De Los Santos versus Spouses Sarmiento, GR 154877, March of 2007. Which has jurisdiction over an action by a condominium unit buyer to annul a mortgage over the condominium unit by the project owner without the buyer's consent and without HLURB approval? The HLURB, since it involves an unsound real estate practice on the part of the project owner. Section 18 of PD number 957 provides that no mortgage on any condominium unit or subdivision lot shall be made by the owner or developer without prior written approval of the HLURB. Concord Condominium versus PNB. Department of Agrarian Relations Adjudication Board. Case: X files an unlawful detainer case against Y before the appropriate Metropolitan Trial Court. In his answer, Y avers as a special and affirmative defense that he is a tenant of X deceased father in whose name the property remains registered. What should the court do? Explain. The court should conduct a preliminary hearing to determine the truth of Y's special and affirmative defense, which is in essence a claim that the MTC has no jurisdiction. The hearing is essential since if there is a tenancy arrangement between Y and X's predecessor, then it would be the Department of Agrarian Relations Adjudication Board rather than the MTC which would have jurisdiction. If the court finds that such is the case, then it should dismiss the complaint. Does the RTC have jurisdiction over an action to quiet title over a public land within the Baguio Town Site Reservation? No. The trial court had no jurisdiction to determine who among the parties has a better right over the disputed property, which is admittedly still part of the public domain. The Public Land Act lodges the power of executive control, administration, disposition, and alienation or alienation of public lands with the Director of Lands, subject to the control of the Secretary of Environment and Natural Resources. Heirs of Pocdo versus Avila. 2014 March, who has executive and original jurisdiction over issues regarding the cancellations of certificates of land ownership awards or CLOAs, emancipation patents, and other titles issued under any agrarian reform program. It is the Department of Agrarian Reform Secretary. In 2009, Congress amended the Comprehensive Agrarian Reform Law through Republic Act 9700. Under the new Section 24, all cases involving the cancellation of registered emancipation patents, certificates of land ownership awards, and other titles issued under any agrarian reform program are now within the exclusive original jurisdiction of the Department of Agrarian Reform Secretary. He or she takes jurisdiction over cases involving the cancellation of titles issued under any agrarian reform program, whether registered with the Land Registration Authority or not. Secretary of the Department of Agrarian Reform versus Heirs of Redemptor, 2019, March. Commission on Audit, DM Konsunji, or DMCI, entered into a contract with the Metropolitan Manila Development Authority, or MMDA, for the construction of an interim waste management project for Metro Manila. However, the project was not completed because of the TROs issued by various courts and because the contract was not signed by then President Estrada. The MCI thus filed with the RTC an action for collection of 19 million against the MMDA, representing reimbursement for expenses incurred in the partial execution of the interim waste management project. The RTC ruled in favor of the MCI. May the judgment of the RTC be set aside? The answer is yes. A liquidated claim against the government falls within the primary jurisdiction of the Commission on Audit, COA. A liquidated claim is one which is determined or readily determinable from vouchers, invoices, and such other papers within reach of accounting officers. This case is one over which the doctrine of primary jurisdiction clearly held sway, for although DMCI's collection suit was within the jurisdiction of the RTC, it was the COA which had primary jurisdiction since the case involved a liquidated claim. The doctrine of primary jurisdiction does not warrant a court to arrogate unto itself authority to resolve a controversy the jurisdiction over which is initially lodged with an administrative body or special competence. All the proceedings of the court in violation of the doctrine and all orders and decisions rendered thereby are null and void. Metropolitan Manila Development Authority versus DM Konsunji Incorporated, February 20, 2019. Keep an eye out for jurisdiction part 3. And if you're not subscribed to this channel, go ahead and hit the subscribe button and let's study together. Thank you once again. See ya.